But I'm so excited to have Liz and Gordon. This is a series. It's going to be a series all summer. The dates will be June 28th, July 19th, and August 16th. Gordon is a financial advisor and special care planner, and Liz is a special needs attorney. So with that, tonight is about government programming and benefits. Go for it.
Thanks, Melissa, for the wonderful introduction. So I'm Gordon, and along with me is Liz.
My name is Liz.
There we go. And so we have a PowerPoint to go through. Do feel free to get your questions into the chat box. We'll do our very best to handle those at the end and are willing to stay a little later based on the questions that we receive. We hope you enjoy the information this evening. It's thorough and there are examples of how these various government benefits work. We have disclosure and about special care. Special care is a program sponsored by the large financial firm MassMutual. It's a network of special care planners across the country. We just happen to be focused on Indiana. And this evening, we're going to be covering SSI, Supplemental Security Income, including the impact of employment. We're also going to be talking about SSDI, Social Security Disability Income, the impact of employment on that, as well as adult child benefits, which is something that many parents find quite eye-opening. We will be talking about Medicaid and Medicaid waivers and also Medicare. Medicare is so often associated with our seniors, that is people that are 65 and older. But as many of you know, Medicare comes with SSDI. And so many of our adult children with special needs actually end up on Medicare before we as parents do. So we'll be talking about Medicare as well. Liz, if you want to lead off with supplemental security income.
Sure. So to be clear, before I jump into this part of the presentation, we are two different companies. I have my own law firm, and then my dad is a certified financial planner with MassMutual. So while we work together, it is important that I make the distinction that we are two different entities. I'm the lawyer, he's the financial planner, and normally we work with CPAs as well. So it definitely takes a team approach to any situation involving special needs trust, public benefits, et cetera. We can't do it all. And I know that especially even with working with clients, they get confused at times with who does what. So that's just a really good disclaimer there of my own. With regard to public benefits, why public benefits? Well, a lot of times when you have a loved one with special needs, they have extra needs, right? We're all special in our own way, but they have extra needs that we hadn't necessarily planned on. So supplemental security income is a program that has been going on for a while, and it might be interesting to know that it used to be at different rates depending on the state in which the amount was awarded, but now it is a federally regulated program. The most that you can get is $794 a month. It's a stipend. It's supposed to be used for food and for shelter. It's obviously not a ton of money, but it has gone up in the years, and we hope that it will go up even still. So it's supposed to be used for food and shelter. But just to briefly explain the difference between Social Security disability insurance and supplemental security income, both are housed under Social Security. The first question any Social Security agency is going to ask, administration is going to ask, is can you engage in something called substantially gainful activity? Again, substantially gainful activity. And that's a number set by Social Security every year. This year it's 1310 unless you're blind, and then you have a little bit of a bump up. If you cannot engage in that amount of money, if you can, doesn't matter what your disability is, you're not disabled enough pursuant to Social Security. If you are not able to engage in substantially gainful activity, then the next question is, have you worked? If you've worked enough what are called quarters, then you may be entitled to Social Security disability insurance. That is an entitlement benefit because it is not enough to be disabled. You also have had to work pay into the program. With supplemental security income, however, it's not a requirement that you work, but it's something called a means tested public benefit. meaning that your assets have to be at or below $2,000 in order to qualify. And that might sound familiar to some of you who are familiar with Medicaid. So the question might come up in your mind of, okay, well, if this is Social Security, so what does this have to do with Medicaid? Well, a few years ago, Indiana decided that they were going to allow Social Security to make the disability determination. So some of you may also be wondering, okay, well, my child doesn't have SSI yet. Have I missed the boat? Have I missed out? And the answer to that is no, you haven't missed out, most likely, because up until the age of 18, your income is deemed to your child to factor into whether they are deemed eligible for this benefit. Up until the age of 18, that's called deeming. The moment your child turns 18, then the deeming stops and then they may become eligible. You can become eligible for Medicaid before the age of 18, but not SSI unless you are not making a ton of money, which is not the best situation to be in. Next slide. So again, I kind of teaser, spoiler alert, already indicated the first bullet point there with the deeming up until the age of 18. There is a first, Social Security disregards the first $20 of any sort of income, and then 65 of the earned income. And what does that mean? So there are different kinds of income under Social Security, two main categories, earned, unearned. You work a job, that's earned income. If you receive child support, as an example, that's unearned income. And why does that matter? Well, that matters because Social Security treats those differently. They want you to earn the income versus unearned. And while we only have a limited scope of time tonight, please know that it does get more complicated than that. And certainly something that we can talk about in specific individual consultations, which we're offering for free and follow up to this series tonight. Next slide. So the summary, this is a summary of factors that can affect SSI. If the consumer must be older than 18, we've already talked about that. If they have somebody else paying their rent or their shelter expenses, that could affect their SSI. That could also involve a special needs trust if not done appropriately. You have to keep their assets at or below $2,000. I've already indicated what SGA is, so we like to abbreviate things and provide acronyms. That's substantially gainful activity. And then child support is a complicated presentation in and of itself, but just know that child support affects SSI. There is a way that can save the situation or make it better involving a special needs trust, but only in certain situations in which that makes sense. So certainly happy to dive in, in an initial consultation to figure out whether that's the best fit for you. And then, and most importantly, I'm not sure why it's last on this slide, but you should be prepared to appeal, especially if you have a child with autism. Unfortunately, autism is something that cannot be seen. It's not to be discriminatory of other disabilities by any means, but it's not like you have Down syndrome and it's all over your face or it's evident. Oftentimes, my brother who has autism, we tell him that, learning is within the box for a neurotypical person, and then you assign autism to it. And it's like you take the lid off the box and he has just infinite ways of learning that we wouldn't have ever thought about. So while it's a superpower, like one of the judges that I was in front of recently said, it can certainly be detrimental to the SSI appeal at process. Next slide, please. And I think that's your slide.
Yes. So let's look at some examples of SSI and employment. And the reason we're focused on this is because more of our special needs consumers are working than ever before, and they're generating income, and in some cases, meaningful income. And so it raises concerns about the impact their having that part-time job is going to have on benefits. So we have situations, and by the way, most all situations in the presentation are based on real life situations with names changed to protect the innocent. So let's start with David, who's age 18, and he gets a job at $10 an hour. He is a student and works weekends with a total of 8 hours per week. He is paid weekly, and therefore he's earning $80 per week, 10 times the 8 hours. In a 4-week month, total compensation would be $320. That's 80 times 4, David receives SSI. So what effect does his $320 a month or so have on his SSI? And the answer is it doesn't. Due to the student earned income exemption, David's SSI benefit is not affected. He can receive potentially the maximum $794 per month in SSI in addition to the $320 per month that he's earning. So in that situation, he's 18, he's still in high school, perhaps he's on diploma track, perhaps he's on certificate track, but David could be literally bringing in over $1,100 a month between his part-time employment and his SSI and maintain all benefits. No reduction to SSI, keep his Medicaid waiver, et cetera. It's not a problem. And I really want to focus on this because many people are concerned that when the child gets a job or achieves employment, that there go the benefits, the loss of Medicaid or waivers or this type of thing. So, and oftentimes it's not the case. And in fact, it's while they're a student, which can be up to the age of 22, either still in high school or in technical training, or if going to something like Ivy Tech or college, that they're maintaining at least 9 hours a semester. And if they do, then they fall under the student earned income exemption. And it's actually quite generous in terms of how much it will allow them to earn without negatively affecting their SSI. Okay, let's move on to example 2, Susan. Susan is 21, no longer a student. She has a part-time job working 20 hours per week, earning $9 an hour. She is paid bi-weekly, earning $360 every 2 weeks. That's 40 hours over a 2-week period at $9 an hour for $360. In a 3-paycheck month, she earns $1,080. The first 85, as Liz covered a moment ago, would not affect the SSI. That's the 65 of earned income plus $20 of any income. The remaining $995 will be reduced by $1 for each $2 earned. Therefore, we take the $1,080, we deduct the 65, now we're, or excuse me, 85, now we're down to $995. You divide that in half, and the $794 per month will reduce by $497, and she'll still draw a payment of $296.50. So in this situation, she earned $1,080 in a month and still received almost $300 of SSI. So the disincentive to work is not strong. Most everyone comes out ahead if they have employment versus not having it, but there are some guidelines to keep in mind. Let's look at a little different situation here. This is Jerry, and Jerry is what we call dual eligible. So he's probably a little older, and he receives $400 per month of Social Security disability insurance or income and $394 of SSI. He is employed at $10 an hour and works 24 hours a week. He is paid bi-weekly. His gross is $480 every 2 weeks. In a 3-paycheck month, his total gross is $1,440. That means Jerry has a problem. At $1,440, his earnings exceed the SGA substantial gainful activity limit of $1,310. This will cause him to lose his SSDI benefit of $400. At his earned income of $1,440, he will also lose his SSI. That's a problem, as the loss of SSI may potentially put his Medicaid and Medicaid waiver services at risk. So it kind of creates a domino effect. So in his situation, it is best to stay under $1,310 a month, where he could receive $1,300 in earned income, maintain the $400 of SSDI, no SSI, but with a total income of $1,700 per month. So it really is powerful to know what some of these limits are, because simply in going over $1,310, he could literally cost himself $400 a month and lose his Medicare, and potentially put Medicaid and Medicaid waiver services at risk. But in staying within the limit, he can have $1,700 a month in income, maintain the Medicaid, Medicaid waiver services, and Medicare. So really, really powerful. So let's move on into, on the heels of that situation involving Social Security disability, let's look at SSDI benefits, including adult child benefits. So this pays benefits to adults who have a disability that began prior to the age of 22. Therein, the reason for applying, if possible, for Social Security prior to 22, if an individual has a disability and can't work full-time. If they're unmarried, or in some cases, if married to a consumer, also Social Security eligible, with earned income under $1,310 per month, and $2,190 per month if statutorily blind as of 2021. So if they're under those limits, then they've either not married, or if married, they've married someone what I call equally yoked, and their disability is documented prior to the age of 22, then they may be eligible to draw this adult child benefit. And as you can see, that gives them a chance to draw off of their parents' record. And they can be eligible to do this for a lifetime. Child's benefit, because it's paid on a biological, adoptive, or in some instances, step-parent Social Security earnings record. For an adult person with a disability to become eligible for the child benefit, a parent must have a triggering event. So when a parent starts drawing Social Security retirement or disability benefits, or they've died with enough Social Security credit to qualify, any of those three triggering events will enable a child to draw off of their record. And these benefits are quite substantial. We have seen benefits, adult child benefits, of over $1,700 per month. You heard me right, over $1,700 per month. And what's powerful is it does not prevent them from continuing to work. They can actually draw an adult child benefit, which again maxes out in the $1,700 to $1,800 range, while maintaining employment, Medicare, Medicaid, and even waiver services. So keep in mind, employment is not the enemy of an individual that has a disability. It's just understanding what the guidelines are. And
so
this,
go ahead,
this is
sorry.
where a parent's record is extremely helpful also. By the way, the first question I'm usually asked by parents who have paid FICA taxes all those many years is, so they share in my benefit? And the answer is no. They receive this benefit over and above what a parent is entitled to receive off of their own record. Now, in some cases, we get into family maximum situations, and time does not allow us to drill too deep into this. But understand what's really important is that decisions that parents make with regards to retirement have a huge ripple effect upon their child with special needs. Now, we've got a little more information to cover, but please be putting your questions into the Q&A box.
So along those lines, let's go rogue for a minute, because when do we ever do presentations traditionally? Can a parent draw their full retirement benefit from Social Security at age 62 if they care for their disabled adult child?
A parent would draw the benefit that they are entitled to based on the age at which they draw and their earnings record. So like everybody else, if a parent of a child with special needs retires at 62 and starts drawing Social Security retirement, your benefit is going to reflect the fact that you started drawing early. If you earned $100,000 a year, your benefit's going to be more than someone that earned $50,000 per year, because there's a difference in the amount of FICA taxes that have been paid. As far as the adult child with special needs, their benefit is based off of full retirement age benefit amount. And so while the parent may draw early and reduce their own benefit, they would not have an adverse effect upon the adult child drawing off of them. Now, where it gets complicated is when we have multiple people drawing off of a single earnings record. And this is part of why it's important to take advantage of the free consultation so that we can drill deep into your individual situation, because there's too many combinations to go over in a workshop setting like this, and we want to look at what applies in your situation. But I can tell you that we are seeing some family situations that between a mother, a father, and an adult child with special needs, the collective Social Security benefits, retirement, and adult child benefit can exceed $5,000, potentially between $5,000 and $6,000 per month from Social Security for the mother, the father person, and the child to boot. So this is really valuable, extremely so. So we want to transition briefly here from drawing off of a parent to drawing off of one's own record. And this is really exciting because 20 years ago, it was rare for a consumer with special needs to have earnings sufficient to where they would literally become eligible to draw Social Security disability off of themselves. But we're seeing it more often these days. So SSDI can replace SSI or be paid in addition to SSI, depending upon the SSI benefit amount. So SSDI may be paid from a consumer's own earnings record. 4/4 of Social Security are earned in a year with $58.80 or more in earnings. So if you're curious as to just how much employment it would take for a consumer to become eligible for Social Security disability, each year that they earn over $58.80, they're getting 4/4 of credit. And at the youngest ages, it only takes 8/4. So literally, we are seeing individuals or consumers with special needs becoming eligible to draw Social Security disability benefits off of themselves as early as age 23 or 24. SSI or SSDI can coexist well with part-time employment. Unlike SSI, SSDI does not require resources to be kept less than $2,000, but Medicaid does. So as long as there's Medicaid and or waiver services involved in the picture, we need to keep for a single person under the $2,000 resource limit. But again, we're seeing more situations like this. So unlike SSDI, unlike SSI, SSDI does not penalize for earned income. As an example, a consumer can earn $800 a month from their part-time job while receiving $400 a month in SSI while retaining Medicaid and Medicaid waiver services. Last slide on SSDI. The consumer becomes Medicare eligible 24 months after their first SSDI benefits are paid. So, so if they start earning or receiving SSDI benefits at 24, they literally have Medicare at age 26. So Medicare can come very early. Child benefits amounts can reach as much as $2,000 a month, depending upon whether the parent's triggering event was retirement, death, or disability. Death benefits or survivor benefits are richer because the child can potentially draw as much as 75% of the parent's full retirement age benefit versus 50% off of retirement. And so if the parent was drawing $3,000 a month, as an example, in a retirement benefit, then the potential exists under survivor for the child to be drawing $2,250 per month. We also have to look at spousal situations, et cetera. It gets a little complicated, but it's well worth examining so that informed decisions can be made regarding retirement, disability, Social Security, et cetera. To maximize the child benefit, the highest parent wage earner would drive their wage up to age 67. So if you want to squeeze the most that you can out of the Social Security system, the largest wage earning parent will literally drive their wages up and retire at 67, because anyone that's going to draw off of them, their benefit will be affected by that full retirement age benefit for the parent. And this includes spouse, disabled adult child, et cetera. So actually retiring at 62 and then taking that part-time leisure job and in the process undermining the full retirement age benefit has a ripple effect potentially on a spouse as well as adult child with special needs. Okay, so I think, Liz, if you could help us as we transition into Medicaid and Medicare.
Before we transition to that, one last question for now, at least. Do you have to be a full-time student for FAFSA of 12 credit hours to be considered a student for the exemption, or can you be a part-time student?
You can be the status for maintaining student status for the earned income exemption, if that's the question, is 9 hours in the college system versus the typical 12 for full-time student status. It only requires nine hours a semester, or that a person be in some sort of technical training like Lincoln Tech or that type of thing. Or if they're on certificate track, they could very well be in high school until they're 22.
Track until they are aged. Send. Okay, all the questions have been answered at this point. Excellent. We're on a roll. All right. So now we're going to talk about Medicaid and Medicare. They are not the same. So earlier on when I was speaking, I was talking about entitlement versus means tested public benefits. Medicare is what's called an entitlement program. It covers medical needs. It's not a financial needs-based program, or otherwise known as a means tested public benefit. It provides benefits for all necessary medical treatment, regardless of the financial status. Again, an entitlement benefit essentially means that it's not enough to be disabled. You have to have paid into the system or have earned the right to have it. And eligibility, generally speaking, is at either age 65 or if you've received SSDI from Social Security Disability Insurance from a parent's record or their own. Medicaid is a needs-based program, otherwise known as a means-tested public benefit. It's implemented by states. So this is something that's come up recently in clients' meetings as well. So Medicaid is a federally based program, but each state handles their waivers differently. So while you may want to move your child down to Kentucky or Ohio or Michigan or whatever, know that your Medicaid will look differently depending on which state you're moving to, which can affect public benefits. Medicaid is government health insurance, and it covers the cost of certain things, not everything. Medicaid is more into subsistence than improving someone's life, but it is something that can be beneficial. And children may qualify if a parent is receiving Social Security or Social Security disability, again, depending on the situation, very fact sensitive, and it funds the waiver benefits. So the things to remember about Medicaid is that it pays medical bills of people who have low income, again, less than $2,000 if you're a single person. States design their own waivers, which may be beneficial depending on which state you're in. You can receive SSI or temporary cash assistance. If you're deemed eligible under Social Security, meaning disabled, then you can get Medicaid in Indiana. It's not that way in every state. And if you're older than 18, your application for SSI is required prior to attaining Medicaid and Medicaid waiver services. Oftentimes the two do not communicate effectively and you have to call multiple times. So that is something to keep in mind. I think this was yours.
Yeah. This, in the interest of time, we won't read through all of this, but this just gives you a smattering of different services available under Medicaid as federally mandated. So it's fairly extensive, but sometimes lacking in areas such as dental care and some other areas. But at any rate, Medicaid coverage in Indiana is pretty thorough. It can serve as a secondary payer to group health insurance or other health insurance. It does serve as a secondary, of course, always to Medicare, where Medicaid or Medicare the person is eligible for. Okay, we're next going to move into waiver programs, and states can waive certain requirements, including the requirement that individuals live in an institutional setting in order to receive Medicaid funding. So waivers came about basically in the late 80s into the 90s. And these programs were the government's response to reappropriating institutions to other uses and for our special family members to stay in the home and community. So the problems were is the government resources were in the large facilities, and also by bringing the kids home or keeping them home, then a family's assets or resources were a factor. So they waived that, meaning no matter what income a parent has or what assets they have, it does not impair the child's ability to be on a Medicaid waiver. So the setting and financial requirements were waived. Eligibility is based on the recipient's, not the parents, the recipient's income, with a maximum of $2,382 per month in total overall income. And as Liz just mentioned a moment ago, the asset or available resource limit of $2,000 regardless of age. So please keep in mind, though the government waives parents' assets and income, they do not waive it for the child. So whether the child is 5 years old or 50 years old, the child is subject to the resource limit and the income maximum. Eligibility for children is based on the child's status, not the parents, and with waiver comes disability Medicaid, which is certainly one of the more sought after types of Medicaid in the state of Indiana. Indiana has approximately 20 types of Medicaid, and the Medicaid that comes with a waiver is usually the type of Medicaid that parents are seeking for their child or children. So let's touch on the waiver programs in Indiana before I turn the presentation back over to Liz. So waivers that are popular in Indiana include the Family Supports Waiver, the Community Integration Habilitation Waiver, Aged and Disabled, the TBI, Traumatic Brain Injury Waiver, and the Choice Program. So we'll just touch on each of these briefly because they are all different. But services in the home and community for those with developmental, intellectual, and physical disabilities is what waivers are based on. So on the aged and disabled, TBI and Choice Program, those are more medically driven physical disabilities. So that's where the most significant focus is that versus intellectual or developmental. There's a shorter wait with these waivers, and they are administered through the area agencies on aging around the state. Family Supports Waiver, which is probably the most popular waiver in the state, has a maximum budget of approximately $17,000 per year, a wait of roughly 8 to 10 months as a result of COVID. It's designed to make time count for you by getting the child on the waiver waiting list. So basically the recommendation there is to engage as early as possible. However, I have parents I meet with regularly. The child is 16, the child's 18, coming out of high school, and they've not engaged yet. And the question is, have we waited too long? And in almost every situation, there is no waiting too long. So now is better than later, but don't think that the ship has sailed or you've missed your opportunity. Most everything with special needs is fixable. So please be encouraged. As complicated as all this stuff is, and help is really good, it's almost never too late to get going with this. In fact, I'm currently working with a family where is 64, and she turns 65, I think, in fact, today or tomorrow. And we are just now applying for a Medicaid waiver for her at age 64. So again, it's almost never too late. So regardless of whether you're an 80-year-old parent with a 60-year-old with a disability, or a sibling, you have a sibling that's in his or her 40s or 50s, it's not too late. And our focus is not just on newborns, it's certainly on individuals with special needs or disabilities at all ages. And what's interesting is that a lot of what we're covering this evening this information was not readily available in generations past. And so I always get excited about helping a family with an individual with special needs that's more mature, where this stuff either didn't exist or information about it was not available 20, 30 years ago. So we love to help. The Bureau of Developmental Disability Services and the area agencies on aging, they're divided up with multiple counties for each office. And we certainly, and the respective office for your county could be helpful with the application process. Okay, then a couple of additional programs, Liz, if you could help.
Yes, absolutely. But first, let's address the question. So first, Charlotte asks, what is the best way to get engagement from BEADS, Bureau of Developmental Disability Services, for help with support for adult child, disabled child while awaiting appeal for SSI? And the answer to that is it depends. Quickly and succinctly, if the adult has received Medicaid up until the age of 18 and then applies for SSI because your income ceases to count because of the deeming, and you apply for SSI and you're denied and you file an appeal, then that Medicaid benefit should continue. If, however, you are not, if they are not receiving Medicaid and they have applied for SSI and you're waiting to appeal, the Medicaid services will not necessarily kick in until the SSI has been awarded. Do you have anything you'd like to add to that question?
No, that's fine. I'll jump in on the next one, and then we've got chat going as well as questions. Okay, I think the next question has to do with income. Max income listed for waiver is $2382, but SSI is $1310. How do these two things work together? You have to have SSI to get the waiver, but the numbers don't match. Okay, so to unpack this, the $1310 per month is what Social Security considers the threshold for an individual to be or not to be disabled. So the most graphic description I can give of income repeatedly exceeding the $1310 is basically screaming at Social Security, I'm not disabled, I'm not disabled, I'm not disabled. So, so that's significant for Social Security. So then if we have 1310, how do we get to 2382? And the answer is that the 2382 is 3 times the $794 monthly maximum for SSI, and it's the overarching income limit. So 1310 is earned income only. The 2382 basically includes Social Security. So, so as an example, if a person is getting $1,000 a month in Social Security, then they could have their $1,300 in earned income, staying under the 1310 and the combination of the two being 2,300. So it's when you add Social Security to the earned income that you get concerned with the 2382. But stay tuned, because in the third installment of the summer series in August, we will be talking about something called Miller Trusts, and that is a solution to the income issue. And so stay tuned for that. Not time tonight, but there's going to be more, and I would encourage everyone, if possible, to make every session, because while we have different topics, there is a bit of building from an information standpoint. But yes, so those are the two major income limits: 2382 when you combine earned income and Social Security, 1310 earned income only. Okay.
Okay, and then Olga Gonzalez, it looks like you have a hand up. Do you have a question? If so, you can type it in the Q&A. But if you do, go ahead and type it in the Q&A and we'll address it as quickly as possible. Okay, so getting back on track here with the presentation at least. There is the Indiana Children's Health Insurance Program, otherwise known as CHIP. This is through Hoosier HealthWise, and it covers children up to the age of 19. Recipients have to be qualified as low income and eligible for Medicaid and uninsured. It covers inpatient and outpatient hospital services, doctors, surgical and medical services, and everything else listed there. Next slide.
Okay.
Next slide, please.
There we go.
Thank you. CHSCS, there's a fun acronym for you. Children with Special Health Care Needs is administered by the state healthcare agencies. SSI eligible children can receive these benefits, and specialized services through the clinics are available. There was a comment in the chat about how, calling BEADS numerous times has proven unsuccessful. Unfortunately, I wish I could tell you that there's a super secret attorney hotline, and there's not. We've had to call multiple times, Social Security and Medicaid both, trying to get answers. Whether it's the pandemic or not, they don't always seem to be the most responsive. And candidly, there's a lot of job turnover there. So I can commiserate with your comment to that effect. Indiana Children's Special Healthcare Services provides supplemental medical coverage to children who have serious chronic medical conditions and ages to 21 years of age who meet the financial requirements. So we have contact information there along with an email should that be of interest to you. So there you go. And with that, I'll turn it back over to you.
All right, thank you.
Mhm.
So coming full circle with what Liz shared early on, understanding the role of a financial professional and the attorney. And Liz was absolutely correct. When it comes to special needs planning, it's a team effort. So I, as a financial planner, special needs planning specialist, I deal with government benefits and financial issues, et cetera, but not the legal. And so, so by teaming together the financial and the legal, it covers most of the bases. And then there are some situations where due to the financial resources involved, et cetera, we also have CPAs that we get involved. So, and then connections with the government benefits and so forth. So it's a pretty thorough approach. But here it shows understanding the financial needs of the individual and how social and medical and legal impact their life care plan, provide a financial needs and legal analysis, coordinate financial and legal strategies with the financial professional and attorney. And by the way, if you've done some planning in the past, then I commend you. If your planning is more than a few years old, I would encourage you to take advantage of the free consultation because things have changed. Documents that I look at that were done perhaps 10, 15 years ago are different than today. And part of this is changes that have occurred with government benefits, and part of it is test cases through the court and what we have figured out works and how the court has ruled on various issues. 20 plus years ago, it was very common to disinherit the child with special needs, and we have such much better options these days. So again, if you've done some planning in the past, it's a perfect opportunity to take a look at no charge with a free consultation and see how your plan measures against what we're doing today. Work together to help ensure that benefits such as Medicaid or supplemental security income won't be unintentionally jeopardized, and know the questions to ask about current and future needs. Help caregivers maintain lifestyle and their loved ones with special needs. And it's all about their quality of life, making a smooth transition to the next generation of caregivers. Okay, I have offices in Louisville and Indianapolis, and Liz has her office in Fisher. So we are nearing the end of this evening's presentation, and it looks like we're right at about 45 minutes, but we'll be happy to take additional questions about anything that we've covered this evening or special needs related.
Additionally, while we do offer free initial consultations, one of the things that unfortunately has been happening a lot in my office is people have asked me to review their documents and then don't bring them to the consultation. I'm very good at what I do, but I can't read minds. So just as a common courtesy, if you could make sure to bring or send the documents in advance, that would help me not waste your time because I can't read minds or pretend that I know what it is without seeing it.
Okay. All right.
Yes,
so
July 19th is ABLE and Guardianships. August 16th, another session you don't want to miss, focuses on special needs trusts.
Right, absolutely. And we'll be talking about the 5 different types of special needs trusts. So if you either have heard about special needs trusts or even have one, there are actually a number of different types. And so I think you'll find the discussion on special needs trusts most interesting. Let's see, Q&A, I think some things have popped in.
Yes, so at what age should we consider starting a special needs trust? You know what, it's never too early.
Yeah.
That's the quick and succinct answer, but stay tuned because there's another session coming and you don't want to miss it.
Yeah. Well, and you just don't know when something may happen to parents. So as the, parent of a child with special needs, you don't know tomorrow's promise to no one. So it's better to be prepared than not. My son just graduated from high school and people have been sending him checks made out to him. Will this unearned income count against him? Should we ask for gifts to be in another form such as gift cards? The answer is it depends upon how much money we're talking about. So If SSI is involved or Medicaid, either one, then you have a $2,000 resource limit. It would be nice to have people so generous that, that we're butting up against $2,000 in graduation gifts. But the key would be just to stay under $2,000, and there's certainly nothing wrong with spending some of the money. So if it goes a little over 2,000, then if there's some computer device or cell phone or something that's appropriate for their situation, then funds can be spent to bring it back down under 2,000. And if they're over 18, you can certainly have them participate in household and other expenses. But it would probably be best to look at that on an individual basis. But maybe it's the perfect opportunity to mention ABLE again, which we will be talking about at the next session, because an ABLE account can be a quick and easy way to offload assets that would otherwise undermine continued benefit eligibility. After a student graduates, is there a grace period when they are still considered a student? It's whichever comes first, meaning the first calendar month after they cease to be a student or the first calendar month following their 22nd birthday. So that's the key there. Terrific. Well, like Liz, I want to thank everybody for participating this evening.